you're not at the podium, I don't want to hear sound distortion. Right now, we're doing what with Mr. Love? Are we picking up hearing?
Picking another hearing date, Your Honor, yes.
What about 15th of December? Locking the whole policy.
The 15th is fine, Your Honor, at 1:30.
Let's just go to 9 o'clock.
9 o'clock.
Be straight up and down 9 o'clock.
Yes, Your Honor.
Is that December?
Yes, Monday, December 15th at 9.
And then, I think I mentioned exactly what I would, that, the board has appointed you to represent Jonathan Young.
Yes, Your Honor. Thank you, Your Honor.
All right, what was the other case you had, Mr. Kelly?
Pardon me. There were actually a couple. Stokes post-conviction we were on for status. I have been in communication with Kit Rogers, who was the trial attorney. He said he's still looking for the file. So if we could just bump that out, perhaps, for status. I think General Fitzgerald's, that was one of hers.
I remember crossing. All right, Ms. Clark is before the court today, having been convicted by a jury verdict, a number of different offenses, vehicle homicide, as a consequence of drag racing as alleged in count 1, the same as in count 2, vehicle homicide by reason of reckless conduct, as alleged in count 3, drag racing causing serious bodily injury, as alleged in count 4, and actually the same offense as alleged in count 5 and count 8. And then the other victim, reckless aggravated assault in count 6 and 9. And then vehicle homicide by reason of drag racing causing serious bodily injury in count 7. And then also the license was in revoked status in count 13. All right, do the parties agree that this Clark is a grand offender?
Yes. Yes, Your Honor.
And so her sentencing exposure on the Class C felonies will be 3 to 6 years on each count, is that correct?
Yes, Your Honor.
And on the D felonies, 2 to 4 years, correct?
Correct.
In our process, the state made a decision on which counts it wishes to merge with the others.
Yes, Your Honor, we're asking, well, one, we're asking for we determine their sentence that we have one for each count. But as far as the merger, we're asking that counts 2 and 3 merge into one, which would be the lead count of vehicular homicide by drag racing. And then for the vehicular assaults and reckless aggravated assaults involving the 2 minor children, we're asking that counts 4 and 5 merge into 6, and those are the ones dealing with HT, the minor victim HT, and then counts 7 and 8 into count 9. And that's dealing with MT. Those 6 and 9 as the lead counts would be the reckless aggravated assaults and serious bodily injury. So what would be left with the 3 counts? 1 vehicular homicide by drag racing, and then 2 reckless aggravated
All right, so
assault.
the lead counts are going to be 1, 6, and 9.
1, 6, and 9, that's correct. Each of those, as far as a service percentage, she is a range 1 offender, but each one of those lead counts has a service percentage of 100% with the eligibility to earn 15% towards eligibility for parole.
So each are 185.
Yes.
All right, let me hear the state's position first with respect to, do you have any additional documents, exhibits, or testimony you wish the court to consider for the imposition of sentence in this case?
Yes, sir. We have, I've asked the pre-sentence report be entered as Exhibit 1. That would be our only documentary exhibit and evidence. And then we have 3 victim impact statements to offer. Matthew Tucker, the father of the minor children, Brianna Plott, who is a cousin, close family member of the Tucker family, and then Nikki Tucker, the mother of the minor children, as well as the daughter of the deceased.
We'll take the victim impact statements before gives Ms. Clark the opportunity to keep any other exhibits.
No, Your Honor. And I would also mention that Jane Mays, also a cousin, is on the teams. She will not be speaking, but I assume she can hear well and doing it's plugged in.
All right, Mr. Jones, do you have any exhibits you wish to introduce in this sentencing hearing?
Just a presenter report, and we're going to be live witnesses from the state.
There will be victim impact testimony from the state. My understanding, they don't have any additional witnesses that they offer. Do you have any witnesses that you wish to tender?
3 current witnesses, statements, 3 current statements.
All right, so you have statements from
We're live.
live witnesses?
We're live.
All right, call your first witness.
Trinity's one.
Ma'am, come around here and take the witness stand, please. Raise your right hand, please.
Do you solemnly swear that the testimony about you in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Just that microphone, if you need to, speak correctly. All right, you're ready.
Good morning, please state your name for the court, please.
Aishma Clark.
And who are you, ladies and Trinity Clark?
I am Trinity's mother.
Can you just answer the question?
Oh,
And you have a statement for the court, ma'am?
yes.
Your Honor, I'm going to check this statement being read. This is not a victim impact statement, she's not a victim. If there's questions that can be answered.
Ask her questions. If she has something that she wants to share with the court about her daughter, obviously I want to hear it.
Do you have any, maybe one statement for your
Yes,
daughter?
I do.
Can you have
Yeah. May I read from this paper?
another statement, just,
That's fine. Just read it.
Thank you. Dear Judge Green and the family of Mr. Williams, I am writing to you as the mother of Trinity Clark. I come before you with a heavy heart, asking for your compassionate understanding as you consider her sentence. For the first, I want to speak directly to the family of Mr. Williams. From the deepest part of my heart, we are truly sorry for your loss. We have prayed for you continuously, and we will never stop. We hate that this tragedy happened to your family, and that you had to endure such pain. Please know that you have our sympathy, that there is not a day that goes by that Trinity and our family don't carry the weight of what you have gone through. From the time Trinity was a little girl, she was thoughtful, curious, and hardworking. I remember how she would stay up with me while I studied to become a physical therapist, going through my books and saying she wanted to follow in my footsteps one day. I was not able to finish college, so Trinity, she would have been the first of my 5 to graduate college. I know she would have completed her time at TSU because of her determination to become someone who could give back to our community. Life presented many challenges for her. She lost her father at a young age. She witnessed me getting raped. Yet she still graduated high school and worked while she was going to school. Trinity went to college where she was thriving. It was only during school breaks while she was home in Knox County that tragedy struck her life. On one break, she suffered police brutality at the hands of an officer in Knox County. That experience left her with PTSD. Yet she showed resilience by returning to school and continuing her education. 2 years later, while home again on break from college, she was involved in a tragic accident on January 17, 2023, which took the life of Mr. Williams and injured 2 children. Trinity has always been deeply connected to her faith, her family, and her community. She was raised in church, played sports throughout her whole childhood, and has always been a sweet, loving, and a dependable young woman. After the accident, she was so remorseful that she even made a personal donation to the family to help in a time of need. To you, Judge Green, and Mr. Williams' family, yes, this was a terrible accident. One that changed the lives of everyone involved in a matter of seconds. Trinity never set out to harm anyone that day. She was only 21 years old, a college student with her whole future ahead of her. I watched Trinity carry deep regret, isolating herself, volunteering to give back, and punishing herself mentally long before even entering into this courtroom. I know my daughter. She is not the person the media has portrayed her to be. She has no criminal history prior to this case, aside from standing up for herself in her lawsuit against Knox County. These tragedies did not come from a pattern of poor choices or recklessness in her daily life. They happened while she was home on school breaks, when circumstances beyond her control collide with her future. I truly believe that prison will not help her heal or grow, not a person like Trinity. Instead, probation will allow her to continue giving back to her community, to share her story, and to serve as an example of how one mistake at a young age can change a life forever. Your Honor, and the Williams family, Trinity has always believed in God, and she has repented for the tragedy of that day. She has a strong support system. Her family, friends, community stand by her and are ready to guide her forward. With probation, Trinity will have the chance to rebuild her life and make amends in ways that prison cannot provide. I respectfully ask that you grant her probation. Please allow her the opportunity to continue on a positive path, to heal, and to become a living example of resilience and faith despite her tragedy. Thank you for taking the time out to hear a mother's plea. With my deepest respect.
Any further discussion?
No, Your Honor.
Cross-examination? Messed up.
Court call. Government call for Simone Williams.
Mr. Jones, I've read every single, I take the state does not object to having the statements that were appended to the sentencing memorandum and made part of this record.
It's just that a victim impact statement kind of denigrates the actual witness.
It's not a victim impact statement. He has the right to call witnesses who can offer evidence about the facts and circumstances of this defendant. What I'm asking is that in lieu of calling every single person up here to read their statement, I understand the state doesn't object to filing those statements as exhibits. I've read every single one. Do you have any other witnesses you would like to call?
Yes, Your Honor. Second reading statement, Your Honor.
All right, call the next witness.
Thank you, Your Honor. Simone Williams.
adjust that microphone so that you can speak directly into it, okay?
Okay.
Correct, Madam Judge.
Thank you, Your Honor. Ma'am, please state your name for the court, please.
Simone Williams.
And where do you
I work for Go Places. It's called Growth Opportunity. It's a program funded through the Department of Labor to work with young adults 18 through 24.
When did you ever contact with Trinity Clark?
As of this date, a year ago, Trinity came in to apply for a program that Go Places provides for employee partners. She was looking to start work with Allow Me LLC.
Did she participate in your program?
Well, Go Places is a program that I contract through for employment, but I also started and founded a program that's called My Daughter's Journey. My Daughter's Journey in Lioness is a program that I also signed Trinity up for because of her age she's eligible to work with. So I work with young ladies from 12 to 50 years of age who are just as impacted, aged out of foster care, homeless or formerly homeless, and providing mentorship, preventive, trauma-informed care, and leadership programs.
In the program with Trinity, did you get a chance to observe Trinity?
Yes, Trinity is in my Behind the Walls program at Roger D. Wilson. I meet with that group on a weekly basis. That's called Lioness. It's also a woman's trauma-informed care program. And through Go Places, her coming in and discussing the reason why she's there and talking about accountability and responsibility of her choices. We talk about how can she heal and make a difference in terms of what she did in the past and how she will move forward and do things. She's always talked about just making amends to the family through the community and finishing her degree, starting a business. So what more emphasis is on the healing part of it, that healing journey. I asked her, okay, if the judge approves probation, what would you do differently in this situation? We know you cannot go back, and my condolences to the Williams family, but what would you do different in this situation? You know, and she talked about stopping and changing her mindset, becoming stronger in her choices and the people that she surrounds herself with.
Have you often worked with women like Trinity?
Yes, I have a lot of my caseload who are also just as impacted.
Thank you, Your Honor.
All right, any questions, gentlemen? All right, thank you, Ms. Sister.
Last quickly, Your Honor.
I'm sorry, did you say you have other?
Yeah,
All right, call your next witness.
Cornisha Smith.
Ma'am, same thing, come around here, please. Raise your right hand, please.
Do solemnly swear that the testimony about you in this case, you will truth, the whole truth, and nothing but the truth, so help you God.
All right, adjust the microphone so that you can speak directly.
Okay.
Please announce your name to the court, please.
Ronisha Smith.
And what organization do you work with?
I work with Cedar Knoxville.
What's your position with C?
I'm the CRP program director.
How did you come into get in contact with Mrs. Trinity Clark?
Well, I've been on her for a while, but I got in contact with her through Go Places. She came in and she did an interview to be in our program. It's an 8-week paid program for ages 18 through 24.
So Go Places gave you a referral for Trinity?
Yes.
And what programs did Trinity participate in at C?
Well, she did an 8-week paid program where it was where she learned life skills, personal development, and job training skills. And we also touched on a lot of mental health.
And is there another program?
Yeah, she also did. She did 5 weeks with urban forestry, and urban forestry work under UT. So what they done was they planted things around the neighborhood. They went out and canvassed and also did things with like gardening and stuff like that.
Did Trinity Clark complete the program?
She completed both programs and graduated.
And this was around September the 2024.
Yes.
Is there a follow-up program that refers individuals like Mrs. Clark?
Yeah, she had the opportunity to go and do internship with UT in their urban forestry. And it's a 20-week program.
Did you ever get a chance to talk one-on-one with Mrs. Clark?
Yes, for the 8 weeks of the program, I do one-on-ones. I do one-on-one check-ins, and during these check-ins, I got to talk to Ms. Clark privately.
Did you ever discuss with Mrs. Clark this incident that happened on January 17th, 2023?
Yes, we discussed it at our interview, and then we discussed it prior to that during our 8 weeks, and also in our cycle time. And during this time, she was very remorseful.
Did you learn anything else besides the remorse from this incident? You know, Mrs. Clark.
I mean, yeah, I learned a lot. Like, it took a toll on her, like, as far as her mental state of being. Like, she would show up and she would help and be present, but she was also, like, gone. Like, as far as it really took a toll on her, like, the way she interacted with people and the way she just, like, her mental health, like, it was real bad, her mental health.
Do you know anything about her educational background?
Yeah, she went to college. She had been in college when the situation happened as well.
Is there anything that you want to tell the court?
I mean, me personally, like, knowing her, I love her. She a great person, and I think she deserves a second chance. Like, she's very remorseful, and I mean, everybody deserves a second chance. So I definitely think she deserves a second chance.
Thank you very much.
Any questions, John? No, Your Honor. You may step down.
No more witnesses, Your Honor.
All right, thank you. All right, General Price, let me hear first the state's position on what enhancement factors are applicable to CF 35.
Judge, as we mentioned in our sentencing memorandum, we are asking under 4035-114 that you consider the enhancing factors 1, 7, and 10. Those are previous history of criminal behavior. The offense involved a victim and was committed to gratify the defendant's desire for pleasure or excitement.
What number 7?
That's number 7. And number 10, the defendant had no hesitation about committing a crime when the risk to human life was high. That's number 10. Really, for factor 1, previous history of criminal behavior, I think at this point all I have is the record that's in the pre-sentence report. So I'm not sure that this qualifies, but it's a conviction for driving without a license.
It qualifies, but it doesn't carry a lot.
Doesn't carry a lot of weight. And it occurred. The only thing I would say about it, Judge, is that it actually occurred after this crash. In January 2023, this date of offense is a little over a year later, in 2024. So despite this crash, he continued to drive without a license. So even though I understand it carries a little weight as far as that factor, because it postdates the offense, I'm not even sure it really fits in that enhancement factor. But I just thought I'd mention that conviction. The main ones, Judge, are number 7, factor number 7, the offense involved a victim and was committed to gratify the defendant's desire for pleasure or excitement. As the judge is well aware from the facts of trial, this was a case of drag racing. There was no emergency requiring them to go that fast. Drag racing obviously being a type of behavior that's engaged in for pleasure or excitement. There's a whole industry in this country built around driving cars fast for spectators and themselves. So obviously it's an exciting thing to do under safe circumstances, but this was not safe circumstances, and there was no justification for it. There was no economic reason to commit this crime. There was no addiction behavior going on, somebody addicted to drugs causing them to their judgment impaired and to do this based on that, based on their impairment or some nature of that situation. All that was done was endangering all the people there on Magnolia Avenue that day, putting their lives in danger because she wanted to have fun for the pleasure or excitement. I think really excitement is what it's about. So we think that factor number 7 should be applied to enhance the sentences within the range of these convictions. And then the defendant had no hesitation about committing a crime when the risk to human life was high. Judge, this, it's in broad daylight, in the middle of a school day, work day, 3 p.m. on Magnolia Avenue, a very busy thoroughfare here in Knox County. And she chose to drive that whole stretch down there at speeds up to, we know, up to 109 miles an hour based on the proof at trial. There is no indication that she hesitated in committing that offense, thought for a moment about all the lives she was in danger, until a moment almost before impact, that she tried to slow down and avoid the crash, but at that point it was too late. So we think that factor should be applied as well, and should be given significant weight. I would note, I mentioned the case, this is appropriate in a situation for reckless vehicular homicide, and vehicular homicide by, in this situation, drag racing, which is really just another form of recklessness. So those are the enhancement factors. Do you want me to go ahead and address consecutive or?
No, let's let Mr. Jones first address whether he believes the enhancement factors are applicable and any mitigating factors that he believes are appropriate based on the record.
Now, was address speeding, driving after the fact. She was dropped that charge on that, and Judge Ward asked her to submit her driver's license, turn them in, and she did. She was without a driver's license for over a year and a half. Without a driver's license, with no incidents of driving or anything else. So
Like I
she
said, Mr. Jones,
understand.
that factor applies. I'm not going to place any significant factor. She's got one, for the PSR, she's got one prior misdemeanor. If I'm looking at that correctly, one misdemeanor conviction. I see a whole lot worse than here.
Yes, sir. Mitigating factors, Your Honor, is
That's not a problem. The other two enhancement factors are also listed.
yes, sir. Mitigating factors are 40, 35, 113, subsection 6. This is falls under youthful impulsiveness. At the time of this incident, she was still informing adult judgment. And her decisions were reckless, but not malice. Subsection 11, same TCA. The conduct was not involved sustaining. Her conduct was not involved to sustain intent to harm anyone. The record reflected Ms. Clark was speeding. She was not intoxicated. And there was no evidence that she saw to injure or kill anyone. We rely on subsection 13. Her post-offense conduct, her remorse, and her commitment to personal transformation. While she was on pre-trial, she participated in several programs, completed them. Even today, where she is right now in jail, she is still attending Bible study, church, and other programs they offer. My daughter's journey is one of them. Number 7, pleasure and excitement, youthfulness. She didn't intend to kill the film, but no intent at all. That case. Just all of it.
Second, Price, state position on consecutive.
Judge, we are asking you to run each of these convictions consecutive. We have 3 different victims. We're asking you to run each one of those consecutive to the other, given the significant, well, obviously we have Mr. Williams lost his life, and the other 2 children were significantly injured, and we'll be dealing with those injuries probably for the rest of their life. That might be addressed in the victim impact statement. But, we think based on that and looking at the actual statute, 4035-115B, 4 is the one we're asking Your Honor to consider that because these should be run consecutive because the defendant is a dangerous offender whose behavior indicates little or no regard for hesitation about committing a crime in which the risk to human life is high. I kind of addressed this already dealing with that enhancement factor number 10. But this decision to engage in that behavior, it was so dangerous and evidenced little regard for the safety of everyone else there on Magnolia Avenue there in East Knoxville. It really could have been anybody on that street. A pedestrian crossing the street, somebody on the sidewalk who happened to be in the wrong place, or anything. All those people were in danger because of Ms. Clark's reckless decision. And so we think that this, no hesitation, no indication she hesitated about committing the crime, and evidence little or no regard for human life. We think that this justifies running them consecutive. And I have cited some cases there that where this has been affirmed in a situation like this, including the co-defendant's case when it went up on appeal. And this was contested. The consecutive sentencing in that case was contested, and the Court of Appeals affirmed it. Obviously, each sentencing is individually determined. So what happened in Mr. Glass's case is not necessarily.
There is specific findings that were made about this identical fact pattern in their case. Which have been learned on videos.
So we would just reference that as well, the reasoning in that particular opinion.
All right, Mr. Jones addressed the state's argument that this case merits consecutive sentencing.
Your Honor, this case should be consecutive sentence before. She did a probation report, and the probation said that she has a strong R risk. This is her assessment. She was a low risk to a reoffend. As far as distinguishing Mr. Glass's case, Mr. Glass has had his first. He was convicted of firearms and evading police. He was put on diversion. We think that was the main reason for the consecutive sentence for Mr. Glass. Mr. Glass has already had his first chance. Mrs. Clark has never had a first chance.
I have to look at this from an individualized perspective, but also when I say if the Court of Criminal Appeals, Judge Sword has already found, and the Court of Criminal Appeals has found certain facts that have to be considered by this court in sentencing about the conduct that took place that day, how do I find it? I'm going to listen to everybody. There may be individualized circumstances here that merit it. One or two of those.
They are individualized. First of all, her age, the first time her age. It was not an intent crime what she did. She was driving fast. The jury said it was drag racing. Mr. Glass had his own probation at the same time. I think that was a great factor that the appellate court used to confirm the consecutive sentences. I think Judge Ford used that against him. So I'm sure when he was sentenced with a diversion, Judge Ford told him that he did do anything else that would be held against him. He was not a range one. Mrs. Clark is a range one. No criminal history, no criminal past. First time ever committed a crime. As far as the courts, sway towards rehabilitation and not incarceration. Just a low, and the PSI said, the recent report says that it's highly unlikely her being a range one in a low offense level to still happen again.
You're requesting probation.
I'm requesting probation or committed to family ground. She has a great support system, as you can see behind me. She was in school when this happened. She's completed 3 years of college, Your Honor. It's 1 year first. She'd be the first person in her family to graduate from college. Setting a great track record for everybody in her family and everybody in the gallery here. She has shown great remorse. When I was first heard of this case, when when I found out that she did the GoFundMe, I felt mixed feelings about that. But she did it on her own. So I didn't ever tell her to do that, and she did it on her own for it. She even got bonded out. I think she's really remorseful what she had. She never took the stand in the trial because she did not want to be questioned and tell a false statement about the incident. And she takes great responsibility for the death of Mr. Williams and the injuries to the Tucker family's children.
Your Price, I'm assuming that the state is requesting the court impose a sentence which includes incarceration.
Yes.
And I'm assuming that you're asking for the same reasons that were enunciated in Mr. Price's case. Let's hear the victim testimony, and they can speak to the stick. Mr. Tucker, if you would come up to the podium, please.
My name is Matthew Tucker. I'm the father of Gage and Hadley. January 17th, you smashed my family's world. And I keep hearing this thing about remorse. Mr. Glass had remorse. I seen that in his trial. I've not seen one damn bit of remorse from this side at all. I keep hearing that word. There's not being any. Maybe from your family, your mother, I've seen remorse, but not from you. Not one bit. As a matter of fact, everybody in this courtroom has seen you act like a victim. My family has had threats, and you are treating us as we have hurt your family or done something to your family. It just blows my mind. My daughter was 5 years old. My son was 10. And we're going to talk about going to college and making smart decisions. I'll tell you a little bit about Mike, the guy that you guys tried to smash and smear his name, that he was a drunk and a drug addict. He don't drink. He's not a drug addict. He retired from UT. I served in the United States Army, and I know about selfless service. That guy was the most selfless person I've ever met in my damn life. The best man I've ever met in my life. I will never be as good as that man. Nobody I know will be as good as that man was. He lived for family, and that was it. He loved his grandkids. That was his whole world. Fishing and his grandkids and his daughter. And to take a man's life like that, and to say, I'm sorry I made a bad decision one day, well, those bad decisions come with consequences. And if I was in the same shoes, I would walk up and hand you my hands and let you cuff me and put my ass in jail, because I would deserve it. Damn right. If you gave me probation and sent my ass home for taking somebody's life, there's no way. I'd probably put a bullet in my head. I couldn't live with it. My daughter, 5 years old, and I want you to think about this. Being put on a ventilator, her jaw was broke in 4 different places. Her neck was broken in 2 different places. Her hip was broke. Every one of her organs were beat to death. She wasn't even supposed to make it. And she woke up at 5 years old, turned 6 at Children's, woke up with her mouth wired shut, not knowing what the hell happened. Just imagine that. Being 5 years old and just waking up in an emergency, in a hospital, with your mouth wired shut, not knowing why you can't talk, why everybody's hovering over you. She was an infant all over again. And my son, his pelvic was crushed in 13 pieces. His face had to have reconstructive surgery. And their papa's gone forever. So, I mean, there's no coming back from that. This world, is worse off without him here. With him here, yes. That man was one hell of a man. He was very honorable, selfless. And you guys ended his life way too early. So, to hear of probation, anything like that, it's just absurd. And the remorse, I've not seen it at all. It's a little late now. And that's all I can say, Your Honor.
Mr. Clark?
Man, come up with those, please. Pull that mic down just a little so you can speak directly into it. If you would state your name, please, and spell it for
Brianna Plott, B-R-I-A-N-A, Plott, P-L-O-T-T. Our family is small, and because of that, we are extremely close. Even though Mike was my uncle and Hadley and Gage are my cousins, I didn't call them uncle or cousins. Mike was a father figure. He was there for me when I needed a father the most. He stepped up when my dad couldn't. My kids called him Papa Mike. And I call Hadley and Gage my niece and nephew, and they call me their aunt. The day Mike was killed, our world turned upside down. I lost my safe person, the one I could depend on, the one I could call when something was broken or wrong. I never actually had to ask, he would just show up and fix it. He was the one who nurtured my love of fishing, camo, and jerky, and all of my love for the outdoors. Losing him, we lost our greatest support. The same day we lost him, my niece and nephew lost their grandfather and now will be physically and mentally changed forever. In the hospital, hearing Gage scream and cry in pain, he was unrecognizable and no amount of pain medication was working at the time. His broken body lay there, his face unrecognizable, and then seeing Hadley in the bed in a coma, unsure she would ever wake, hearing the small whimpers of pain coming from her as she woke, it will forever be seared into my brain. The one thing I'm thankful for is Mike's oldest grandchild, Allie, had a last-minute change in her schedule and wasn't in the vehicle, but that didn't stop her from being affected. I'll never forget hearing her cry in the hospital, saying she should have been there to help. Hearing her deal with survivor's guilt was the most heartbreaking thing. Seeing the difficulties that Gage and Hadley are still having to deal with scars fading is still gut-wrenching. They'll never get to be normal children. Gage loved playing football. He'll never get to play football again. Hadley loved gymnastics. It's too dangerous for her with a brain injury to be a gymnast anymore. Their lives are changed forever, and we're just supposed to accept it and give mercy when we don't feel like mercy was given to us. That is all.
Now Nikki Tucker.
I have the option today to give a victim impact statement to let everyone hear how the actions of Ms. Clark has affected my life. I'm going to speak for the real victims, the ones that can't speak for themselves. On January the 17th, 2023, due to the direct recklessness and complete disregard for others' lives, my father's life was needlessly ended. We lost a father, a grandfather, and an uncle. I lost a father I could always depend on, and my children lost their closest family member. I'm going to speak for my children. I want to describe their injuries. My son, Gage, was 11 and suffered an extreme concussion, multiple disfiguring lacerations to his face, multiple breaks and dislocation of his hips, a shattered pelvis, a torn bladder, and a damaged liver. My baby, Hannah, was only 5. She suffered a DAI brain injury, a torn exterior ligament, multiple breaks to her jaw, multiple breaks to her neck, broken ribs, broken arm and wrist, a broken pelvis, a torn spleen, internal bleeding, and damaged lungs. She was in a coma and had to be put on a ventilator. She awoke to a nightmare, a world of pain that no child should have to endure. It's been 2.5 years and both my children are still recovering. Both will have lifelong disabilities, especially Hadley due to the traumatic brain injury. As a mom, I cannot put into words what it's been like to see my children go through this level of suffering. I felt it is important to voice this, to show the depth of the assault charges, to go through this nightmare, to plan a funeral with my children in critical condition in the hospital, for them to ask for their papa only to be told he didn't make it, the grieving while enduring a long, painful recovery, multiple surgeries, feeding tubes, wheelchairs, their normal life completely gone, replaced by hospitals, doctor's appointments, home health, and rehab centers. The ripple effect is long and long-reaching in all aspects of our life. I hope that I have been able to convey some of the lifelong impacts of these crimes for my dad, Michael Williams, and for my children, Gage and Hadley Tucker. I pray for justice.
Clark, before the court composes judgment, this is your opportunity to speak. You wish to require this is your opportunity. Pull that mic up.
Thank you for allowing me the chance to speak. I want to begin by saying how truly sorry I am for everything that happened on January 17, 2023. I never intended for anyone to lose their life or to be injured, for any lives to be changed in this way. I understand nothing I can say can take away the pain and the loss that this has caused. I want the Williams and Tucker family, as well as this court, to know that I am deeply sorry in the fact that Mr. Williams lost his life and Hadley and Matthew Tucker were seriously hurt. I think about it every day, and I carry this weight with me every day. I take full responsibility for my actions that happened on January 17, 2023. I made a terrible decision, a decision that I cannot take back. But I want the court to know that I have learned from this experience, and I choose and want to do better. Since the incident, I've had the time to think deeply about my life, my choices, the future I want to build for myself and for my community. I now understand just how quickly one bad decision could change so many lives. I also realize that my life does not have to end with this mistake, that I still can have a chance to become someone who contributes to society in a meaningful way. While I've been in jail, I have been attending church as well as Bible study. I have also joined a mentoring program called Daughter's Journey, which I have gotten the chance to help rebrand into Lioness Rising, a group that provides positive role models and support for all women. This program is helping me grow, and it's shown me that I can make a difference in someone else's life, that I can turn my pain and my mistake into something positive. If the court gives me a chance if the court gives me the opportunity, I would like to continue counseling, community service and working to prevent other young people from making the same mistake I did. I want to be a voice for change, use my experience to help others avoid the path that led me here. I'm not asking to be excused for my consequences. I'm asking for a second chance, the chance to prove that I am more than this mistake I have made. Thank you, Your Honor, for hearing me.
Court and those who judge in this case, the entirety of this record, consider statements made by Ms. Clark, consider testimony, trial, pre-sentence investigation, the impact statements, and the entirety of the record before this court. This is a case that I've tried several hundred cases, either as a judge or as a lawyer. If I lived in 95 or 100, I think I'm in for this one. There's a couple things that stick out to me and will always be what I remember about this case was court. And one is when the testimony was introduced that 2 seconds before this crash, your foot was to the floor, the accelerator was to the floor, and you were doing 100 miles an hour. And the other is the first image that I saw, photographs of this wreck scene afterwards. It looked like a motorcycle. Because when 2 vehicles that are going over 110 miles an hour struck another one, before things happened. All enhancement factors are clearly applicable in this case. You do have a previous history of conviction. It is just of no real consequence. I'm not going to place any significant weight on that. But clearly enhancement factors 7 and 10 are applicable. For whatever reason, just to prove who had the faster charger, I don't know what the rationale was between you and Mr. Glass, but you decided that it would be a really good idea, really fun, to go on to one of the busier thoroughfares in this county and see who had the faster charger. For the rush of seeing who could make it someplace faster, the rush of just going that fast, I don't know what it was. Clearly this factor is applicable. But the most applicable factor, here's enhancement factor 10. You had no hesitation about committing a crime when the risk was going to his high. There's a reason that the speed limits on the interstates are a lot faster than they are places like Magnolia Avenue, Kingston Pike, because on the interstate there's not pedestrians, there's not people crossing over as they turn to go into businesses. When you're on a thoroughfare such as Magnolia Avenue, the risk that somebody could be hurt by your conduct is it's magnified with every single foot, every single boat of vehicles took. You know, if a young man who happened to have the camera on his helmet on that moped, and then 2 or 3 seconds later, he probably would have been killed too. There were multiple people all up and down Magnolia Avenue that day that could have been hurt or killed by your conduct. And neither one of you all cared. It's a rush of the moment, I guess, that they go. So clearly, enhancement factor number 10 applies, and the court places significant weight on this factor. So the court will impose a sentence on each of these counts. Well, recommended for those reasons. You are young. I will consider that fact that you have no significant criminal history. I will consider that fact. But I'm sorry, the enhancement factors greatly outweigh the mitigation that's present in this case. The media has covered every single moment of this trial. quite frankly, this case is shocking. It is aggravated beyond the normal case of this nature. You had not only a gentleman who lost his life, but you had two young children who suffered grievous injuries that they will bear with them and carry with them for the rest of their lives. I mean, a 5-year-old girl, because of your conduct and that of Mr. Glass, suffered significant brain injuries. She will struggle with that for the rest of her life. A 10-year-old boy had his body broken up because of your conduct. The court specifically adopts and incorporates those findings made by Judge Shepard in Mr. Glass's case. Your case is different only in that you weren't on version at the time. It does not change the gravity of what happened. The facts that day, as Bill Price said multiple times when this case was tried and he argued it took them time to do it. Mr. Glass is not doing 109, I'm convinced, 109 or 110 miles an hour down Magnolia unless you're charging him trying to do the same speed. And that's the reason that this gentleman lost his life, and that's the reason that both of his children were seriously injured. So confinement is necessary for the reasons that the court just stated. Consecutive sentencing is also warranted in this case. I don't think you were a bad person, but you're a dangerous person. The decisions that you made that day were dangerous. You had no hesitation about committing a crime with the risk of human life. It's not just high, it is a miracle for anyone were killed by your conduct in that Mr. Glass. The sentence that the court is getting ready to impose is reasonably related as well to the severity and the necessity of confining you just like Mr. Glass in this case. The public needs to understand, Ms. Clark, that you can't have this kind of conduct. Every single one of us, when we get on the road and see people that think it's a good idea to zip in and out of traffic, do 90 miles an hour down the interstate, putting other motorists at risk. Everybody that does that needs to understand that if you do that, there's a consequence. There's a real consequence for it. So you understand this. Stand up, please. Ms. Clark, on each of the Class C felonies, specifically in count 1, you were found guilty of vehicular homicide by reason of drag racing. You were sentenced to a term of 6 years within the Tennessee Department of Correction as a range 1 offender. In count 6 and 9, you were found guilty of vehicular assault or drag racing resulting in serious bodily injury as well as reckless aggravated assault. You were sentenced to a term of 3 years on each of those counts. Each of these cases, for reasons stated, will be served consecutively one to the other in the Tennessee Department of Correction for a total aggregate sentence of 12 years. I considered giving you 14. I really did. But you and Mr. Clark, or excuse me, you and Mr. Glass are similarly situated. We'll give you the same sentence because that doesn't go on with that. Then judgment court waiver court cross that you serve the sentence in custody. Need to schedule this for motion to withdraw. I'm assuming, Mr. Jones, that you wish to have a transcript prepared for the motion to withdraw. You need to make certain you get the motion filed within 30 days of today's date. Get the motion for new trial filed, this begins to be a placeholder motion, and then you can amend it later once you get the transcript. Let's set this out maybe late January just to see where the court order is. Yes, file the letters, Mr. Jones appended to us. Since memorandum as an exhibit. All right. Let's take about let's pick a date. What's the last Friday? Put it on January the 30th for motion to trial. We probably won't have a transcript by then. Mr. Jones, once you get the transcript, you can amend the motion. All right, 30. I'm sorry. January 30th. January 30th. about a 10-minute recess, we'll come back to the
No, you drink.
They're doing a recess.
Are you done?
No, they're doing recess.
12 years, same thing he got. That's kind of what I